Thank you. Mr. Adams, you recall earlier this morning when my learned friend was taking you through a paragraph on page 4 and a paragraph on page 11?
Yes.
He was seeking to make a meal out of their use of language, if I can put it that way. It is correct to say that notwithstanding what has happened thus far in this proceedings, there is still an absence of evidence of wrongdoing, as you say in paragraph on page 11, against the following: Appley, Sperling, and Kemp, the Bank of Butterfield Executor Trust, Sir John Swan, and the individuals who the property was sold following the subdivision into individual lots.
And your question, sir?
And so it is still the case, what you say in that paragraph, in the absence of evidence of wrongdoing, there does not appear to be grounds of justification for such a finding in respect to Appley, Sperling, and Kemp, the Bank of Butterfield Executor and Trust Company, Sir John Swan, and individuals for whom property was sold following subdivision into individual lots. Nothing has changed, has it?
That's correct.
Thank you. Can we turn now to the evidence of the what is called the Summers Report? I want to take you to a couple of extracts from that report. If that could be put up, CNLB 5, I believe it's called.
Yes, sir. Just please give us one moment.
Sure, sure. And while you're looking for that, we'll also need the one marked A-AP, the deed from the Book of Deeds office with the Registrar General's seal in the front of it.
So Wayne, could you repeat the last one you're referring to? Last.
It's the AAP. That's how it's marked on mine. It's this one here with the big red seal on it.
Oh.
Can you advise, has that been tendered into evidence?
Yes, sir. You have it in your possession.
As
I'm not sure that's the correct. I'm not sure that's the correct exhibit number. That's why I'm holding it up for you. Let's see if I can find it. I think actually CNLB 10 may be the right one. I'm looking at my notes from the earlier hearing.
Probably
Ferguson to Augustus?
Yes. That what it is? It's from no, Augustus to John Swan. It might be JS1 too. That's another. I was never thoroughly confused with the marking system. But you've got the right. Let's start while you can.
Yes,
while we deal with this. Could you scroll past to page 2? Stop there. Can come a little higher. I'm going to read it out for speed and expediency. It says commitment, contingent and limiting conditions. The second sentence there, Mr. Adams, does it not say through thorough searches have been made of the applicable registries in Bermuda and the old parish vestry records?
Correct.
Could you stroll to page 3, page 4, page 5, page 6? Well, I think that might be, yes, that's it. That's perfect. At the top there, the first complete sentence says, there is no record in the Registrar General's office of a conveyance, voluntary or otherwise, of lot 4 or any part thereof between 24th of January 1962 and 17th of January, 1972. It says that, does it not?
That's correct, sir.
And could I ask for, we'll come back to it. I put to you that JS1, if that's the actual number, is a deed which comes from the Book of Deeds, number 108, page 2040 to 246 in the Registrar General's office, and is certified as being so, made the 21st day of July 1970. We'll come back to that because I'll have them put that up so you can see the document, okay?
Yes, sir.
Could we go to the next page, please, of the Summers report? Oh, there you go. Here's the document now. Let's stay there. So if we could go to the next page. So you see the top is 21st day of July, 1970, between John Emmanuel Augustus and John William David Swam and Peter James Chalmers Smith, et cetera, et cetera. Was this deed ever referred to in the Summers report, which I believe was made in 1996? Yes, it was 1996. Was that, as far as you know, referred to in the Summers report?
I don't think so.
So if it wasn't referred to in that report, then that last sentence I read, that there is no record in the Registrar General's Office of conveyance, voluntary or otherwise, of Lot 4 or any part thereof between the 24th of January 1962 and 17th of January 1972 would be false, wouldn't it?
Run that by me again, sir.
Sure. I asked you, I read out to you, I read out to you a sentence. I'll do it a little slower maybe. There is no record in the Registrar General's Office of a conveyance, voluntary or otherwise, of Lot 4 or of any part thereof between 24th January 1962 and 17th of January 1972. And I point out to you the deed JS1, which is the one I had just flashed on the screen, or the one that's right on the screen there. That does exist, and it's come from the Registrar General's office, so that makes that statement wrong, doesn't it?
You're talking about the statement in the
In the Summers report, yes.
yes, correct.
Right, thank you. So we identified two mistakes in Mr. Summers' report. Let's carry on. The last page, please, of the Summers report.
Jurisdiction.
Yeah, thank you. Last page. Just above conclusions, that paragraph there, it says, there is no record in the registry in the form of a recital which sets out how this real property came into possession of the grantor in the earlier voluntary conveyance listed above. That's what it says, doesn't it?
Yes, correct.
When clearly there was a record in the Registrar General's office, 21st of July, 1970, yes, I will check that, make sure I'm saying it correctly, 1970, which predates that conveyance set out the 30th of December, 1970.
I think so, yes.
Go on down, scroll down, please. No, I think you went backwards. Gotta go down. There we go. There we go. Right. We'll go up a bit. That's fine. Great. The research on which this report is based did not reveal any record of John Augustus Alexander Virgil disposing of Lot 4, Plan 7, or any part thereof between the 24th of January 1962 and the 17th of January 1972 when he died or had that or before that period. If we could please go back to JS1. And if you go to down a bit. These are known as recitals. You see the where, stop there at the whereas, go back up, please, a little bit up there. Whoa, stop there. These are known as recitals. And the first recital, A, it notes that on the 15th day of April, 1969, Russell Pierman, as the first part of vendor, and David Edmund Wilkinson, the third part, and did release the property onto the vendor and his heirs. Now, the vendor in this case is John Emmanuel Augustus, referred to above. If you go back up above, you'll see it says vendor after his name. He's identified as vendor. You'll see it there, a third line down from the top, 1, 2, 3. That's John Augustus. So that recital identifies Mr. Augustus as having purchased it from Mr. Pierman on that day. And if you go to the second page of this document, and you come down,
Excuse me.
okay, then, right. So if you come down from the number 2, all that certain land, and you follow that through, delineated and outlined in pink on the plan being drawing number 7084-4-2-69, prepared by Wycliffe Stovall, annexed to an indenture dated the 15th day of April, 1969, and made between John Augustus Alexander Virgil of the first part and Russell Levi Pierman of the second part, and David Edmund Wilkinson of the third part, and thereupon designated for A, B, C, D, E, F, G, H, and a roadway bounded blah, 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 blah. That refers to an indenture, which is a conveyance from Mr. Virgil to Mr. Pierman, does it not?
Yes, I think so.
So that statement is also suspect. Finally, on back to the.
I'm sorry. I'm sorry. Is that? Would you like us to make a note of that, Mr. White?
Well, I see no reason why you shouldn't.
No, I'm just wondering because you say that's it. The witness hasn't answered, so I just wonder if it is your what
Oh,
you
no,
have
no,
said.
no, not my. I don't give any evidence, sir, as you well
Right.
know.
So let him answer then. Let him answer.
Certainly, certainly. If I cut him off, I apologize. Mr. Adams?
Yeah.
I think they require something more.
What are you asking of me?
I'm saying, does it not say that there was an indenture between Mr. Virgil and Mr. Pierman dated that date, which I read out. Can't see right now.
Where is that on this page?
Okay, just come right, stop and look at it. It says being drawing number 7084-4-2869, prepared by Wycliffe Stovall.
Yes, I see that.
Okay, annexed. It's just, I got to refocus here. Annexed to an indenture, which is a conveyance, you'll accept from me, dated the 15th day of April, 1969, and made between John Augustus Alexander Virgil, the first part, and Russell Levi Pierman of the second part, and David Wilkinson of the third part, and goes on to say other things.
Yes.
It refers to an indenture dated that, does it not?
I see it, yes.
Thank you. Finally, back on the Summers report. That's fine, thank you. The second last paragraph. The record did not reveal how any part of Lot 4, Plan 7 came into possession of John William David Swan at the time that he voluntarily conveyed the 6 lot derived from Lot 4 to Leslie Earl Ming. It says that, doesn't it?
Correct.
Mm-hmm. And yet you have found in the Sands Parish records references to the transfer to John Swan.
Yes.
And I have found and produced to you the John Swan JS-1 book of deeds deed, which is another deed and evidence of the transfer to John Swan. Isn't that correct?
Yes, correct.
So this report is misleading, is it not?
Correct.
Because it is not accurate, it was not thorough, and does not reflect the actual position of the transfers and deeds and references in the various registries.
Correct.
It's not, I'm not saying that the report is designed to mislead. It's misleading by its absence of accurate information.
I think things were left out.
Yeah, well, that's another way of putting it. I'll accept that. Thank you. You heard Miss Petty's evidence, did you not? You've read her evidence, I should say.
Yes, read it.
And were you present when she gave her evidence? I recall you being there, maybe?
Yes.
You were, okay, you heard her. You recall that Miss Petty was accepted as an expert witness in documents. And you recall her evidence that, and I'll paraphrase for want of a better word, that she was not examining original documents.
Yes.
And that she had not been given any information about the medical condition of Mr. Virgil.
Yes.
She also sets out in her report and confirms that at page 3 of her report, paragraph 13, could I have a report put up, please? Thank you so much. Could you go to page 3? Paragraph 13, down a little further. That's it, perfect. The first sentence of paragraph 13, all documents received were copies and were scanned in as PDF documents and received by email transmission. That's what our report says, does it not, Mr. Adams?
Correct. Excuse me.
If we could flip to page 5. Do you recall Ms. Petty also saying that people's handwriting changes as they get older? That doesn't remain constant, I think the words that she used.
Yes.
Okay. Could we look at page 5? Paragraph, going down a little bit further, please, to paragraph 17. There you go. And she notes there is a 5-year difference between the closest comparison document, 1964, to the 1969 question document. Okay, and in fact, there's also a document just above, you can just see above there, a 1956 document. So many years difference between the 56 document and the 69 document. And at the end of all of this,
Where's the 56 you're talking about, sir?
Just go to the top of the, did you see the John Virgil signature there? You'll see
Yes.
the date in the block there. It says it's 1956. You may not be able
Oh,
to.
yes, yes, all right.
Thank
Yes.
you. All right. She then goes to give her opinion. That's on page 12. Okay. Page 12, paragraph 14. So she's given her opinion, but she's caveated that opinion in her oral evidence and also in her written evidence by giving those caveats about it's a copy, giving a caveat about the medical history, giving a caveat about the difference in time between the signatures, etc. And she comes to a conclusion as follows at paragraph 34A. There is a probability that the 4 question signatures of John Augustus Alexander Virgil, John Augustus Virgil labeled Q1, 2, 3, and 4 are not genuine and not written by the hand of John Augustus Virgil stroke John Augustus Alexander Virgil stroke John Augustus Virgil. She says that, does she not?
Yes.
And she says the same thing in B, virtually, about Mr. Doors, that there's a probability that 2 question signatures of Allinger and Doors labeled Q Q3A and Q4A are not genuine and were not written by the hand of Alger and George, right?
Yes.
So she uses the word probability. She doesn't use the word certainly not, were not. She uses the word probability, does she not?
She does.
And she very helpfully provided at page 1, at the very back of her report, it's page 1 of the standard terminology of expressing conclusions of forensic document examiners. Here we go. Thank you. Thank you. That's perfect. Could you come down to 4 and maybe blow it up, because that's going to take some looking at. That's better. So the terminology that is recommended is at the highest standard of terminology to use when you're sure is identification, definite conclusion of identity. This is the highest degree of confidence expressed by a document examiner in handwriting comparisons. The examiner has no reservations whatsoever. Though prohibited from using the word fact, the examiner is certain, based on the evidence contained in the handwriting, that the writer has of the known material actually wrote the writing in question. The next one down says strong probability, highly probable, very probable. The evidence is very persuasive, yet some critical feature or quality is missing so that the identification is not in order. However, the examiner is virtually certain that the question or known example is written by the same individual. Turn the page, and we come across the word she used, probable. That means the evidence contained in the handwriting points rather strongly towards the question and known writings as having been written by the same individual. However, it falls short of the virtually certain degree of confidence. Now, these are talking about identifying someone as having written it. I would respectfully suggest to you, they also apply when you're saying it wasn't written by the person, because she used that word in that context, that it was not written by John Augustus Alexander Virgil.
Chairman, I'm not certain that he can answer that question unless counsel respectfully is pointing to an instance where she in fact said that something was not written.
She does.
But,
That's what she says. She says, if I'll go back, so just make good what I just said. There is probably the 4 question signatures are not genuine and were not written by the hand of John Augustus Alexander Virgil. That's what she said.
Right.
In
And
written
just,
evidence.
sorry, and just to complete my point, so what I'm concerned about is this witness. But probably I'm premature in my answer. I'll let you finish. I'll premature in my objection. You go ahead.
Okay. So using the document provided by the handwriting expert, it's to suggest, or the document provided by the handwriting expert suggests that her confidence falls short of virtual certainty of a degree of confidence in her statement.
And before the witness answers that question respectfully, Mr. Chairman, Ms. Petty was here. Ms. Petty, I recall counsel elected not to put any questions to her. It cannot now be asking this witness to answer something that Ms. Petty, the person who supplied the document that has the definitions, has the terminology, to ask this witness to be placed in that position, respectfully.
This witness, with the greatest respect, Mr. Chairman, is a very experienced investigator of some 41 years, 33 years in CID, well used to dealing with fingerprint evidence and experts.
But nevertheless, Mr. White, as counsel has reiterated, he is not the substantive witness. The witness was Ms. Petty, and those questions were not put to her at the time. And it perhaps would be unfair to this witness to even request an opinion on what would be expert witness. The witness before you now, Mr. Adams, has already expressed some reservation about Mr. Waddell, the police handwriting, quote unquote, consultant. I wouldn't call him an expert at the time of the original investigation of the matter. And now, secondarily, we have a witness who, albeit has had copies of handwriting, albeit has give what I would call a conditional answer. I would not expect this witness to give you a definitive answer. I think it would be unfair to him, and the answer would perhaps not be the best.
Well, it could be, you've suggested something, sir, which may actually cure the problem. Yes. Would you agree, the question I want to put, sir, just before he answers it, is that would you not agree, Mr. Adams, that the witness, Ms. Petty, gave a conditional answer on the identification of the handwriting?
And that I would object to. She would have to be asked herself if her answer was conditional based upon the terminology. That's a question properly put to her.
Not necessarily.
It is not for this witness to indicate whether her answer was conditional or not. She's the
Well,
one who gave it, make her the document.
Well, we could ask the witness this question. And do you think her answer was conditional or unconditional?
I'm objecting to that too. That's for the witness.
I've made my point. I'll move on.
Yes, Mr. White, I think we have a bit of a, I wouldn't call it a massacre.
I'm moving on. I don't want to delay unnecessarily.
Yes.
Coming back to your report, Mr. Adams, do you still stand by, notwithstanding Ms. Petty's report, with the exception of anything to do with Mr. Pearman? I want to keep that separate because let's leave that separate for the time being. Do you stand by your report and its conclusions? At page 11, 12, and 13, I think, yes.
Yes.
Okay. And in those conclusions, you state that Mr. Modier, who knew John Virgil, having drawn up a will in 1964, was certain it was Virgil who attended his office and instructed him to send the deeds to his property to Pearman's lawyer, David Wilkinson. You also say that money exchanged hands with a $6,800 being found deposited in Mr. Virgil's account at the Bank of Butterfield, right? And that you offer some observations on Mr. Virgil's condition, which I don't think are germane. I won't go into those. And you also opined on the Bermuda Caribbean Engineering Consultants report in the rest of your conclusions. And finally, you noted, Mr. Adams, on the final paragraph of your report, that there were two civil jurisdiction of the Supreme Court copies of which were obtained. Efforts to ascertain the outcome of several others are ongoing with difficulty encountered in locating the relevant files. I will put to you, we have submitted a number of cases to the panel, of which there were 5 cases by the Browns against my client and others, not 2. And you do note there were others, but you couldn't get copies of them. They were of some vintage, none of which the plaintiffs were successful in.
I'm sorry, just before the
question's coming. The question's coming.
Oh, okay.
The question's coming. So I put to you that on 5 occasions, Mrs. Brown particularly took Sir John Swan or John W. Swan Limited to court, and on none of those occasions were they successful.
I believe that's correct.
Okay, thank you. Finally, there is no evidence that has been presented to you, I believe, that shows of any wrongdoing by my client.
There has not been.
Okay. Has there been any evidence produced to you of any wrongdoing by the Bank of Butterfield, Executor and Trust Company?
No, sir.
Any evidence presented to you of any wrongdoing by John Virgil, the other Virgil?
You speaking of John Alfred?
Yes, the other Mr. Virgil.
No, sir.
I think, Mr. Chairman, that is all I need to ask Mr. Adams.
All right, thank you, Mr. White. Counsel, do you have any follow-up questions from that?
No, I have one or two in your examination, but I'll just follow the train and allow Miss Virgil and Mr. Hanson to go first, and then I will come after. Sure.
In that case, I would invite Ms. Virgil to submit her, I would say cross-examination, her examination of chief of Mr. Adams.
I'm
And
just going to ask at this time, Chairman, just a caution in terms of we may just be going on Facebook for a few moments.
yes, that's correct. If the technicians could do that.